Good morning, Ms. Levinson.
Good morning, Your Honor. Good morning. May it please the Court. My name is Beth Levinson, and I represent the defendant, Andrew Kevin Burke. The question before the Court today is whether the Massachusetts courts have subject matter jurisdiction to modify an Oregon child support order where neither the husband, the wife, nor the children reside in Oregon, where the husband, who is the responding party, is a resident of Idaho.
Where do you say these people are supposed to go?
Idaho, Your Honor.
Why Idaho?
Because that's what the statute says, pursuant to the Uniform...
That's what UFSA said.
Yes,
Right.
the Uniform Interstate Family Support Act.
But isn't
What
that
about the federal statute?
The federal statute, I would suggest, Your Honor, does not preempt the state statute because the federal statute...
does not what, the state statute?
Preempted.
Preempt, thank you.
A lot of courts disagree with you.
Your Honor, I have tried extensively to research the issue of preemption of the Uniform Interstate Family Support Act. I have found two cases, one out of Tennessee and one out of Kansas, which are in accordance with the position of the defendant in this matter. With regard to the state court decision that this trial judge relied on, the Vaughn case, which was decided by Judge Langlois in the Norfolk Probate Court, the cases that he cited, which he claims were in accord with the majority of the states which advocated preemption, in fact did not preempt the Uniform Interstate Family Support Act, but its predecessor, the Uniform Reconciliation of Support Act, which was expressly...
Ms. Levinson, just as a practical matter, if you assume jurisdiction means personal jurisdiction in the federal statute, doesn't it make sense that this would be the forum to have this? I mean, since nobody is in Oregon anymore, you've got the mother and the children here. The father has accepted personal jurisdiction here. Why isn't this the right forum?
Your Honor, respectfully, because it frustrates the purpose of both the federal and the state statutes.
The federal statute?
The federal statute. The purpose of the federal statute was in order to, under the Full Faith and Credit for Child Support Orders Act, was to facilitate the enforcement of child support orders and to discourage continuing interstate controversies over child support, and to avoid jurisdictional competition. The only way jurisdictional competition can be avoided is if the word jurisdiction in the federal statute is read to require both personal and subject matter jurisdiction.
Why? I mean, it seems to me that what's at issue underlying the federal statute very clearly and UFSA is when somebody is the recipient of monies pursuant to a child support order. It seems to me that what the federal government and the uniform commissioners were trying to do was to say if somebody isn't paying, if the mother isn't paying the child support payments that she has to pay, it shouldn't be the obligation on the father to have to go to where she is, provided that there's personal jurisdiction, because you've got a constitutional problem if there's no personal jurisdiction.
That's exactly right, but this is not that case, Your Honor, respectfully. This is not to do with the enforcement of the support order, but only with the modification of the order.
Doesn't make any difference.
Under the statute, it does make a difference, Your Honor. I would respectfully request that the modification of the order and the enforcement of the order are under separate sections. In order to modify a foreign order, it would be unfair under the statute to require the obligating party, the obligor, to travel. This would give the...
But that's what personal jurisdiction is all about. That's what always happens in personal jurisdiction issues.
Your Honor, the purpose was to avoid having conflicting states having multiple orders from conflicting states.
We deal with that. We deal with that by ultimately getting every state court to agree. At the moment, we've got a split, so I understand. But what you're not going to get, I think it is highly dubious under either the federal or the uniform law that if the father now went into, where's he, in Idaho?
Yes.
Into Idaho court, it would be very unusual for the Idaho court to assume jurisdiction. So we're not going to get conflicting orders.
the father cannot get jurisdiction in Idaho. In order for the father to get jurisdiction to modify the order, he has to come to Massachusetts.
Yeah, so you're not going to get conflicting orders.
But you will under the federal statute, because the federal statute, if you read jurisdiction to mean just personal jurisdiction, it gives both jurisdiction to Massachusetts and
Can you
Idaho.
help me out with something, excuse me, about the state statute, Chapter 209D? I don't understand when it says a petitioner who is a non-resident of the Commonwealth seeks modification. Why would a petitioner who is a non-resident here come here for modification?
That would be the husband who wants to modify the support order has to go to where the wife is the resident if he wants the wife to have a change in the order.
If he wants the support order reduced.
Yeah, he can't.
That's correct. He cannot do that in Idaho. He has to go to the forum where the wife is the
There
resident.
won't be conflicting because there would be under the federal statute because there is no personal jurisdiction over the wife or the children in Idaho.
But the wife could, in fact, to submit to jurisdiction in Idaho.
She's not going to.
Well, that is the situation under the state statute. The state statute would require her to go to Idaho, and the federal statute would not. So you would possibly have conflicting orders which could not be reconciled. That
But
would
that's the point of preemption, isn't it?
Well, the preemption in this case, I would suggest to you, Your Honor, the federal statute is in fact ambiguous when it comes to the word jurisdiction, because the way it defines jurisdiction is it refers to a lower subsection, which actually is in fact the registration of the support order.
Was
And
personal jurisdiction conceded here by the defendant, or did the judge rule that Massachusetts had personal jurisdiction?
It's my understanding that it was initially contested. The judge found jurisdiction, and it is not the subject
Personal
of
jurisdiction.
I apologize.
Personal
jurisdiction. And it is not the subject of the
So it's been waived. The challenge to personal, whether it's conceded or waived, it's technically.
It's not
been-
before the court.
Yeah,
That's
it's not an issue.
It's not an
That-
issue.
That's correct. But the problem is that if, in fact, the husband is forced to come to Massachusetts, or in any situation where the obligor is forced to travel, this would, in fact, give the moving party a license to go from state to state to state to try to establish residence
Not
for
if you
herself
don't-
and try to modify the support
No,
order.
because
can
there
she
wouldn't be personal jurisdiction.
Exactly.
There wouldn't be personal. So let's say she moved tomorrow to New Hampshire. I don't think there's any contact between your client and New Hampshire. She couldn't do it in New Hampshire because there would be no personal jurisdiction. Underlying personal jurisdiction, is the constitutional premise that whoever the party is, here the husband, former husband, has sufficient contacts with Massachusetts, so she couldn't move from state to state.
Your Honor, it was a concern of the legislators that both the state and the federal statute would be but I agree with your analysis with regard to the New Hampshire situation. I apologize. But with regard to the federal statute, it was a concern of the framers that both the federal legislators, that both the federal statute and the state statute be construed harmoniously. In fact, the uniform statute was mandated. This language was mandated language by the federal government in order for the states to receive federal support to assist in enforcement of child support orders. In addition, with regard
But you're asking me to draw a distinction between enforcement of child support orders. Take this hypothetical, okay? At the time that the divorce occurs in Oregon, your client is unemployed or a graduate student. Let's make him an unemployed person. And so, support is set at some appropriately de minimis rate, given that he can't make anything else. And let's assume that 5 years later, he's living in Idaho, she and the children are in Massachusetts. He comes frequently to Massachusetts to see the children. He's a very good father. He visits his children. They go to Idaho, but he comes here too, because you can't always take children to Idaho. And then because he is, a computer whiz, or he invents Facebook, or he does something, he suddenly has assets which are far greater than he had 5 years before. There's personal jurisdiction over him, and she wants a modification of the child support order. Not alimony, nothing else, just the child support order. Where is the unfairness of asking him to come to Idaho, where he comes presumably on a regular basis because there's personal jurisdiction.
One of the concerns, Your Honor, of the legislature
Yep.
was that if, in fact, a visiting parent was subjected to being served for modification orders every time that parent wanted to see his or her children, it would discourage family relationships and contact between family and children. This is expressed in the legislative history of the Uniform Statute, and the legislature wanted to avoid that situation, did not want to discourage contact between the parent and the children, and specifically said, we understand that this places a burden. Nevertheless, we are going to require that the party seeking a modification go to the jurisdiction where the obligor resides. That's specifically, Your Honor, one of the concerns of the legislature in framing the Uniform Statute. I'd also like to point out to the court that the court in 1996, as part of a welfare reform bill, the Personal Responsibility and Work Opportunity Reconciliation Act, indicated that part of the intent of the legislation was improved child support enforcement in interstate cases, and specifically stated that the federal statute is to be applied consistently with the state statute, the Uniform Statute. The federal government recognized that they wanted the Uniform Statute applied and that the federal statute was to be applied consistently with that state statute. Therefore, when we consider the legislative intent behind the state statute, I would submit that the language of the state statute should be applied as is, and that there was no intent on the part of the legislature to change or modify, and there should be no preemption. Again, with regard to preemption, I would submit to the court that the federal statute should only preempt the state statute if the two cannot be applied harmoniously. And in this case, they certainly can be. If this court is to determine that the jurisdiction under the federal statute means both personal and subject matter jurisdiction. Unless there are any further questions?
Thank you, Ms. Levin.
Thank you very much.
Ms. Levy?
Good morning, Your Honors. May it please the Court. My name is Tamara Levy, and I represent Patty Draper, who is here with me in the courtroom today.
Ms. Levy, how can we say that the federal statute preempts the state statute in light of the language of the 1996 Welfare Reform Act?
Well, the federal statute preempts the state statute because it directly conflicts with the state statute, and actually the language of the federal statute is very clear on its face and is not ambiguous.
It can't be read harmoniously with the state statute?
It cannot be read harmoniously, and in fact, this court actually, in the case of Delk versus Gonzalez, decided in 1995, ruled that the federal counterpart to this rule, which dealt with custody and visitation issues, the Parental Kidnapping Prevention Act, preempted the state statute, the uniform, the UCCJA. In that, the interesting thing about that case is similar to the situation here. The federal Congress actually mandated that the state adopt this model statute that 50 states actually adopted, but the court still found that the federal statute preempted the state statute. So the argument that when Congress mandates that a state adopt a model statute, that means that you are supposed to read the two harmoniously.
Did Congress in that situation also say that the federal statute is to be read and applied consistently with the state uniform statute?
Well, I'm not aware that there is language to that effect. It's my sister relies primarily on the case of Letelier, which comes out of the Tennessee court, and I don't believe that this court should follow that case. That case did say that the two should be read harmoniously, but if you read it carefully, the logic in that case is flawed. The facts are different in that case.
So Congress didn't mandate that the statutes were to be applied harmoniously. The federal statute was to be applied harmoniously with the state statute. That doesn't come from congressional
I don't
language.
believe so, Your Honor. I attached to my brief in the addendum There is the congressional purpose, and
Well,
there are
let
notes.
me put it this way. I think Congress was intending to be, to not conflict with UIFSA, that's clear. But one way to read UIFSA is that in its exclusionary provisions, because UIFSA and the federal statute were very careful to try and not have, in this case, Oregon, I think, and Massachusetts dueling it out, because nobody was going into Idaho. One could read that the petitioner, who's a non-resident of the state, is, in fact, would cover the situation where the Idaho resident, he now, used to be a fully employed engineer, and he's now lost his job, and he wants to come into Massachusetts, and Massachusetts is saying, how can I hear this case? Because, a Massachusetts court has to say, should it be Oregon or Idaho? And what UIFSA says is, no, it's perfectly okay if he wants to seek modification here. That's okay. You can do that because there's not going to be a conflict with Idaho. It's a sort of glitch in the law. And so if you read the statute that way, then the federal statute is not inconsistent with UIFSA.
Right, that's right, Your Honor. There is, in the congressional purpose, it's quite clear that the intent was to protect the recipient of child support, and in the instances...
Put it differently. Let's assume that the father in this case did not have any contacts with Massachusetts, right?
Right.
And he wanted to modify the order, right? He wants to modify the order. The court is going to be nervous. The court, he's starting it. Does the court have personal jurisdiction? I presume that what UIFSA is saying is he can come here and modify.
Well, the court has personal jurisdiction over the mother and the children who are living here, for sure.
Right, exactly.
Correct.
In that instance,
So-
Your Honor, it makes sense that he come here because...
No, but
He could come here anyway, couldn't he?
Right.
Well, this is a funny set of laws because normally you can go sue anywhere that you want to go sue, as long as the court has jurisdiction. But what both statutes are designed to do is to make sure that if she went to Idaho, let's say she went to Idaho and filed and initiated, which happens, and initiated a complaint in Idaho, then the issue is not only personal jurisdiction, it is competing courts and to make sure that there's only one proper place.
That's right. That's right, Your Honor. And to
What
make
would the situation be if they had no personal jurisdiction over him?
Well, that's
Where
really-
would these people go?
Idaho.
Would she have to go to Idaho?
She would have to go to Idaho.
That's right. That's really at the crux of this. I mean, the federal statute is designed to make sure that the only court that can have jurisdiction over a modification is the court that has personal jurisdiction over the defendant. And that's actually the clear language of the statute. When you look at Section I, it says that if all the individual contestants and the children have left the original issuing state, then the petitioner can register the foreign judgment in the state that has, and the language specifically is jurisdiction over the non-movement. Now, this Tennessee decision interpreted that word as being ambiguous, but there's nothing ambiguous about jurisdiction over the non-movement. When you deal with construction of a statute,
It's not jurisdiction over the case, it's jurisdiction over the
Exactly.
non-movement.
Personal.
Person, yeah.
exactly, it actually couldn't be clearer. In legal context, that is the definition for personal jurisdiction.
Then what is your explanation in UIFSA of subparagraph little 2? Whatever, that's the petitioner who is a non-resident of the state seeks the modification.
Right. Well, I think that originally, I know that these laws stemmed out of concern that there would be conflicting jurisdictions, but, concern over the recipient of the support. There is attached to my brief are congressional notes, and there's an interesting story in there from Barney
saw it.
Frank that helped to pass this. And he talks about a woman that called him from Massachusetts and was upset because her ex-husband moved out of state, and he sought a reduction in the other state. So my explanation for that language is that appears to have stemmed out of concern, out of those concerns that the obligor can move out of state and file wherever he is. And that doesn't make any sense.
But he couldn't have done that, because if he had moved in Idaho, let's assume there was, if he moved to Idaho, let's say he was originally in Massachusetts, the divorce is in Massachusetts, she stays in Massachusetts, he moves to Idaho. Under UIFSA, he cannot file in Idaho because he is not a non-resident.
Right.
So that, the Congressman Frank,
But that was in the passage of UIFSA, right?
Excuse me?
Oh, I see what you're saying. But UIFSA came after this law, didn't it?
no.
Well,
The other way around?
I think it was adopted in 1995, and the federal statute came out in
But
1994.
but how do we apply that
UIFSA,
subsection?
it might have been adopted here, but UIFSA was, the uniform commissioners had promulgated, I think, UIFSA before that.
How do we apply that subsection 2 in this case? Saying that, because here the petitioner is the mother, and so how do we apply it? It says a petitioner who is a non-resident of the Commonwealth seeks modification. But here it's a petitioner who is a resident of the Commonwealth who seeks modification.
Right, that's right. And
So what do we do with that subsection?
Well, what we do is we say there's a federal statute that addresses this very issue. It addresses what we do in a modification when the original order is from another state. And that federal statute does not impose a residency requirement. And when federal and state law conflict with each other, we're required to follow the federal statute. And it works here. In these, it requires that there be personal jurisdiction, that there be a nexus. And we have that here, and it's important to remember that the facts in this case are quite compelling. Many the other cases from other states that talk about this actually don't have this set of facts. You've got to remember, in this case, the parties were married here. They grew
That's
up.
irrelevant, though. I mean, I know it may make a difference to the way your client feels, but for UIFSA and for however we pronounce the federal statute, FF, whatever it is,
Well,
what's the shorthand word for practitioners? Just the federal statute?
I like to refer to it that way, Your Honor.
Okay, that's as good as any.
It is relevant because the federal statute talks about personal jurisdiction.
Yes, but if they had been married here, am I correct? For modification purposes, if they had been married here, then moved to Oregon, and he had never set foot again in, and they'd lived there for how many years did they live in Oregon? Like 9 years or something like that?
No, they were only there, I think, 3 years.
Whatever it was. And he never
Yes,
sets
four.
foot in Massachusetts again. He has no contact with his children. There may even be an order that says he cannot have contact with his children. Not this case, but there could be such an order. And Massachusetts, it's not did Massachusetts once have jurisdiction over him, it's whether Massachusetts now has jurisdiction over him. So what difference would it make, again, for UIFSA or the federal statute purposes if they were once married in Massachusetts?
Well, it makes a difference because under the long-arm statute of the state law, Chapter 209D, Section 2201, there have to be sufficient he has to have sufficient contacts with this
Pleasant
state.
contacts.
Present, but many of them relate to the children and his
Yeah,
contacts.
but I'm giving you a situation where the father has or the parent has no contact with the children, no contact with Massachusetts, either by choice or by court order. Then Massachusetts would not have personal jurisdiction, even if they had married here. Correct?
Right, I don't think that their marriage necessarily is what gives them jurisdiction. The statute talks about having lived here in the Commonwealth with the children having been conceived here. In this case, they were not only married here, but they lived here for 10 years of their marriage. The children were born here. They lived here for the majority of their marriage. And mother, this is not a case of forum shopping, mother returned to the home state with the children. And I also, in my brief, I referenced the Klingel decision, which came out in 2006, and it's somewhat different. It deals with enforcement of a foreign, not a foreign order. It deals with enforcement of an order, but there's a lot of talk in that case about the importance of nexus, the state having a nexus to the litigation. And here we have that. We have to find that that the state has an interest in the litigation. And in this case, we certainly have that.
What if the father still resided in Oregon? Would that make any difference?
Absolutely. Then
Yeah,
actually,
what is your view on that?
well, that's actually very straightforward. If the father resided in Oregon, then there's no question that that's
Oregon
where,
is the only state that has jurisdiction,
right.
correct?
That's really how it works. Is the original issuing state
Of the divorce and the
End of the order.
of the divorce,
and the
right?
child support orders.
It retains continuing exclusive jurisdiction so long as at least one of the parties or the children remain in that state.
Is there a way to resolve this without getting to the preemption issue? Or do we have to conclude that federal law preempts state law?
That's a good question. We have to conclude that that federal law preempts, but my position is that it's actually very clear that getting back to the Letelier decision, which I don't believe this court should adopt, they really have taken a stretched position to find that the federal statute did not preempt the state statute.
Haven't a number of states already held that it does preempt?
I'm not aware of that. I think that states that have ruled on this have tended to be more followers. But that Letelier case, if you look at it closely, it really doesn't make any sense. It stretches the word jurisdiction. It takes it beyond.
Well, because it doesn't say it. I mean, well, that's a separate thing. One of the things that I found missing here, and maybe it doesn't exist, is that they're very helpful, I think, from both parties, statutory history, congressional history of the federal statute, but not a lot on what drove subparagraph 2, the petition to be a non-resident of the state. Have you looked of UIFSA? Have you looked at the statutory history of UIFSA? I mean, you'd have to look at the history of the Uniform Commissioners, not Massachusetts statutory history.
Yeah, actually, there's something in the notes, and I have it cited in my brief, that says specifically that if federal law conflicts with state law, that federal law governs.
No, I understand that, but I'm trying to find out what the purpose of subparagraph 2 for modification was.
Right. It's similar to the purpose of the federal, which was to make sure that only one state at all times had jurisdiction over these issues, to make sure that there were no.
I understand that, but Ms. Levy, if you're the parent, you have the father here being ordered to make child support payments, and he is making them, and he is, meeting all of the obligations that he's required to meet under the divorce and the child support payments. Isn't it unfair to command that he come into Massachusetts to defend against a modification when he's not seeking the modification? Isn't it more fair to say to the parent seeking the modification, you go to where the other parent is, because underlying all of this is that two parents are in different states. If they were in one state, no problem.
No, Your Honor, I think notions of fairness would actually dictate that he come here. You have a mother that is seeking financial assistance. The kids are older. They're now going to college, and she needs help. And all the contacts are with this state. Idaho has no connection whatsoever, other than it happens to be his choice of residence. Your Honor, I would submit that it's illogical to find that any other forum.
Let me ask you one last question. Assume that that they obtained the divorce in Oregon. He moves to Idaho. She moves to Massachusetts with the children. A year later, he moves to Massachusetts, and she seeks modification. Am I correct that under his interpretation of UIFSA, she cannot seek modification?
Your Honor, I'm not sure that I followed your fact pattern again.
Okay, the fact pattern is he was in Idaho, they are now both in Massachusetts,
Okay.
and she wants modification. Does those provisions only apply when, they're not in Oregon.
That's a good question.
Am I correct that
Right.
under his interpretation, she couldn't seek modification in Massachusetts, even if he were resident in Massachusetts, because she is a non-resident party.
No, I don't believe that. I think where they're all here, jurisdiction is here.
Under what section?
I'm not certain. I can't refer you to
Okay.
that.
So you're saying that that provision applies only when they are applies only when they're in different. It's not how I read the statute, but maybe I'll have to go back and read it. Thank you, Ms.
Thank you very
Neville.
much. Thank you for your time.